and thank you for choosing the Legacy Lawyers as your source of information. We know this might be a difficult time you're going through, but we are here to educate you and help you through the process. Please stay tuned for our question and answer portion.
Good morning, Aaron.
Good morning, David. Thank you so much for joining me.
Sure.
So, a lot of people have questions about conservatorships. What is the difference between a conservatorship of the person and a conservatorship of the estate?
Okay. Well, a conservatorship is a court-supervised proceeding in which someone is appointed to make decisions for someone who cannot make their own. So there are two different types of conservatorships. The same person can be the conservator in both types. It could be different people. And a conservatorship of the person is someone who is appointed by the court to make the decisions necessary for the conservatee's personal needs of food, clothing, health care, and shelter, whatever personal needs that they may have that they cannot make decisions for or appreciate the consequences of their decisions. So that person is a conservator of the person. And those powers allow them to make certain medical decisions or decisions as it relates to where the conservatee lives and so on. However, those powers do not relate to any sort of financial management decisions. So a conservatorship of the estate is established for someone who cannot resist fraud or undue influence, someone who cannot make decisions for their financial well-being or understand the consequences of their decisions. So a conservator of the estate is appointed to make those financial decisions. And that is a fully supervised proceeding, except in limited circumstances. The conservator of the estate would be bonded, which is like an insurance policy, so to speak. And that person will be required to render accountings to the court on a periodic basis. Those accountings would then also be circulated to members of the family. And an accounting essentially states, well, here are the assets on hand at the beginning of the conservatorship accounting period. Here are they at the end. And here's an explanation of the difference between the two in terms of income received and checks paid out, let's just say to a care facility. So a conservatorship of the estate relates to finances only, and a conservator of the estate would not be able to decide where the conservatee gets to live or to authorize medical treatment. They are two separate and apart sets of powers. Now, oftentimes is the case that one person is appointed to handle both. And just as often, you have two different people. For example, the loving daughter or son who lives with mom or lives close to mom can be appointed as conservator of the person. That person generally takes mom or dad to the doctor's appointments, participates in the appointments, dispenses medication, does all sorts of things, bathes mom or dad. All those personal decisions are made, generally speaking, and with the imposition of a court proceeding, it might be appropriate to appoint that person formally. That person might not have any ability to manage finances. So, or the finances may be so vast, which is not a bad situation to be in, but so that you need a bank or a professional fiduciary, or maybe the other sibling who's also CPA or a CEO or runs their business that knows how to do bookkeeping. Sometimes it's appropriate to appoint someone different in certain cases.
Okay. Thank you very much.
Sure.
And remember, if you have any questions for us, feel free to email us at smm@thelegacylawyers.com. Thank you so much.